Chapter 4 Privacy. When it comes to privacy and accountability, people always demand the former for themselves and the latter for anyone else. So what is the National Security Agency or NSA up to? The National Security Agency is responsible for making and breaking codes, intercepting signals, and supporting U.S. military operations. It operates a vast telecommunications network, including ground-based stations and secret listening posts, and uses advanced technology to crack encryption codes. Once intercepted, communications are analyzed for suspicious activity and stored in massive data centers, while NSA activities are legally limited to foreign communications. Concerns have been raised about potential violations of privacy rights and civil liberties. Despite denials by NSA officials, past revelations have shown instances of warrantless eavesdropping on Americans. Financial data. Individuals are required to disclose significant personal financial information to access various financial products and services such as credit cards, loans, and brokerage accounts. This data is typically safeguarded using personal login credentials like usernames, passwords, and account numbers. However, the inadvertent loss or disclosure of this information poses a considerable risk to privacy and potential financial loss. It's essential for individuals to ensure that business and organizations adequately protect their personal financial data and refrain from sharing it with unauthorized parties or companies. The Fair Credit Reporting Act, enacted in 1970 and enforced by the U.S. Federal Trade Commission, governs the operations of credit reporting bureaus. It regulates the collection, storage, and use of credit information to ensure accuracy, fairness, and privacy. The Act outlines guidelines for accessing credit information, disputing inaccuracies, and determining data retention periods. It also prohibits credit reporting bureaus from disclosing information to employers without written consent from individuals. The Right to Financial Privacy Act, passed in 1978, safeguards customers' financial records from unauthorized government access. It requires customers to receive written notice and an explanation if a federal agency intends to obtain their records. Along with procedures to oppose disclosure, government access to records requires customer authorization, an administrative or judicial subpoena, a search warrant, or a formal written request. Financial institutions cannot release records until government compliance is certified. The Act applies only to federal government disclosures and does not cover private businesses or state and local governments. The Gramm-Leach-Bliley Act, or GLBA, of 1999, also known as the Financial Services Modernization Act, repealed the Glass-Steagall Act and allowed financial institutions to merge, leading to the rise of conglomerates like Bank of America and Citigroup. GLBA also introduced rules affecting personal privacy. First is the Financial Privacy Rule. Requires financial institutions to disclose how they collect, share, and protect customers' financial information and allows consumers to opt out of data sharing. Two is the Safeguard Rule. Mandates financial institutions to document data security plans to protect clients' personal data. Three is Protecting Rule. Addresses attempts to access personal information without proper authorization, encouraging safeguards against such practices. However, the law's privacy disclosures were often lengthy and complex, leading many consumers to inadvertently opt into the data sharing due to cumbersome opt-out process. The Fair and Accurate Credit Transactions Act, FACTA, of 2003 aims to enhance the accuracy of consumers' credit reporters and protect against identity theft. It includes provisions such as free annual credit reporters for consumers, the ability to dispute inaccuracies in credit reporters, and requirements for businesses to properly dispose of sensitive consumer information to prevent identity theft. FACTA also introduced measures to improve the accuracy of credit reporting and enhance consumer rights in cases of identity theft.
Health information. The use of electronic medical record and subsequent interlinking and transferring of the electronic information among different organizations has become widespread. Individuals are rightly concerned about the execution of privacy of data concerning their health, their intrusion in their into their health data by employers, school, insurance firm, law enforcement agencies, and even may marketing firm looking to promote their product and services. The primary law addressing the issues in the Health Ins- Insurance Portability and Accountability Act. The Health Insurance Portability and Accountability Act, or HIPAA of 1996. It is safeguard the privacy and security of individuals' health information. It established national standards for the protection and confidential handling of protected health information, or PHI, by healthcare providers, health plan, and healthcare clearinghouses. HIPAA ensures individuals' right to access their health information, restrict its disclosure, and be informed about how it's used. Additionally, HIPAA includes provisions for the electronic enhanced or exchange of healthcare information to improve efficiency and accessibility while maintaining privacy and security. The American Recovery and Reinvestment Act of 2009, a comprehensive legislation located $787 billion for expending and tax cuts over a decade. Title number 12, Subtitle B, known as Health Information Technology for Economic and Clinical Health Act, HITECH or HITECH, included robust privacy protection for electronic health records. This provision prohibited the sales of health information, encouraged the use of audit trails and encryption, and granted pa- patient right of access to their health record. Children's professional data. According to research, teenagers spend more than 5 hours per week online, with a significant tone report tongue that their parents and unaware of their online activities. Additionally, a considerable number of teens have received requests for personal information online, and a notable percentage have been approached by strangers online. This finding highlight the need for safeguarding children for inappropriate content, online predators, harassment, and potential involvement in risky behavior. Despite this, existing laws aimed at protecting children online have faced constitutional exchanges regarding freedom of expression. The Family Education Right and Privacy Act, or FERPA of 1974. It is a federal law that grants parents certain rights regarding their children's education records, which transfer to the student upon reaching 18 or attending post-high school education. This right includes access to education records, control every disclosure of records, ability to aim records, and the right to file complaints for violations. FERPA ensures student records remain private, with penalties for violation potentially including the loss of federal funding. However, the laws enacted before the internet age has faced changes in adapting to modern data sharing. practices. Recent regulation have slightly eased restriction allows limited data sharing among government agencies involved in educational program. The Children's Online Privacy Protection Act or COPPA enacted in 1998 mandates that website directed at children must provide detailed privacy policies, notify parents about data collection practices, and obtain parental consent before gathering personal information from their under 13 under 13. COPPA aimed to give parents control over their children's online data. Though it does not address information dissemination to children, and law has led many companies to invest significant resources in compliance effort or cease targeting routine altogether. For instance, Artist Arena faced a legislation of collecting personal data from over 100,000 preteens visiting its fan club sites for popular singers and agreed to a $1 million settlement obtained to delete any collective information to resolve the master.
Electronic surveillance. This section covers laws that address government surveillance, including various forms of electronic surveillances. New laws have been added and old laws amended in recent years in reaction to worldwide terrorist activities and the development of new communication technologies. Communications Act 1934. The Communications Act established the Federal Communications Commission and gave it responsibility for regulating all non-federal government use of radio and television, broadcasting, and all interstate telecommunications, as well as all international communications that originate or terminate in the United States. The Act also restricted the government's ability to secretly intercept communications. Foreign Intelligence Surveillance Act or FISA, established in 1978, outlines procedures for electronic surveillance to gather foreign intelligence information from communications involving foreign powers or the agents. Surveillance within the U.S. is permitted for up to a year without a court order, unless it involves U.S. citizens, in which case judicial authorization is required within 72 hours. The Act also empowers the U.S. Attorney General to request assistance from communications carriers for surveillance activities. Additionally, FISA established the FISA Court, which meets secretly to review surveillance warrant applications. These applications are rarely denied, as evidenced by the Department of Justice 2011 submission of 1,745 applications without any denials. Title 3 of the Omnibus Crime Control and Safe Streets Act, also known as the Wiretap Act, regulates wire and oral communications, interception by law enforcement. It requires obtaining a warrant from a judge based on probable cause and limits surveillance to specific situations where other investigative methods have failed or are too dangerous. The act stemmed from the case of Katz v. United States, where the Supreme Court that ruled that warrantless electronic surveillance violated Fourth Amendment rights. Court orders under Title III must detail the surveillance scope and efforts to avoid capturing innocent conversations. In 2011, federal and state judges authorized thousands of wiretaps, resulting in numerous arrests and convictions. Amendments to the Wiretap Act have been made through laws like FISA, ECPA, CALEA, and the U.S. Patriot Act. The Electronic Communications Privacy Act, or ECPA, of 1986, addresses the protection of electronic communications during transfer and storage, and prohibits unauthorized recording of dialing information. Title 1 extends Wiretap Act protections to electronic communications, requiring court orders and for interception. Title 2 Stored Communications Act prohibits unauthorized access to stored electronic communications with exceptions for public accessibility. It also allows for National Security Letters or NSLS to obtain subscriber data without judicial review. Another part permits court-approved use of pen registers and trap and trace devices. Amendments to ECPA are being considered to address text messages storage requirements. The Communications Assistance for Law Enforcement Act, or CALEA, it was passed in 1994. Amended the Wiretap Act and ECPA, requiring telecommunications companies to facilitate court-ordered eavesdropping on conversations and intercepting electronic communications. CALEA addressed gaps in coverage for emerging technologies like wireless modems and cellular data networks, ensuring law enforcement access to electronic communications. However, it sparked controversy over privacy concerns and potential security vulnerabilities. Last, the USA Patriot.
Fair information practices. Fair information practices encompass a set of guidelines governing the collection of utilization of personal data. These principles, developed by various organizations and countries under different names, aim to curb unlawful storage and dissemination of personal data, eradicate inaccuracies in stored data, and prevent unauthorized disclosure or misuse of such information. The issue of cross-border data flow concerning the movement of personal data across national boundaries is a significant concern for many organizations and countries. Fair information practices serve as the foundation for numerous national law addressing data privacy and protection concerns. Fair information practices, the Organizations for Economic Cooperation and Development, establish guidelines for the protection of privacy and transborder flows of personal data in 1980. Comprising 34 member countries including major economies like the United States, Japan, and Germany, the OECD aims to foster policy consensus crucial for global economic progress. These guidelines, based on 8 principles, serve as a benchmark for ethical handling of consumer data. Despite being non-binding, they have influenced data privacy laws globally, although variations persist across. Fair information practices. The European Union Data Protection Directive of 1995 mandates that any company operating with Europe must adhere to privacy directives, ensuring fair and appropriate use of personal information. It requires member states to safeguard data transferred to non-EU countries and prohibits data export to nations lacking comparable privacy standards. Key principles include notice, choice, use limitations, security, correction, and enforcement. Concerns initially arose regarding data privacy standards, but a safe harbor agreement was reached allowing certified firms to enhance European data. In 2012, the European Commission proposed a new data protection regulation to replace the directive, aiming for uniform data protection standards across the EU to streamline operations and reduce administrative costs. Access to government records. The government has a great capacity to store data about each and every one of us and about the proceedings of its various organizations. The Freedom of Information Act enables the public to gain access to certain government records, and the Privacy Act prohibits the government from concealing the existence of any personal data record-keeping system. Access to government records. The Freedom of Information Act, enacted in 1966 and later amended in 1974, empowers citizens to request access to certain government information and records at federal, states, and local levels. It serves as a crucial tool for journalists and the public to obtain information that the government entities may be hesitant to disclose. FOIA procedures have been instrumental in revealing details about significant events such as President Kennedy's assassinations, tracking congressional visits to the White House, accessing government agencies' budgets, and investigating historical incidents like the alleged UFO incident in Roswell in 1947. However, it's common for requested information to be redacted before release. Access to government records. The Privacy Act of 1974 regulates how federal agencies collect, use, and disclose personal data held in record systems. Promoting transparency and accountability, it requires agencies to publicly disclose information about these systems and outlets. Specific requirements to protect individuals' privacy rights while exempting certain agencies like the CIA and law enforcement. It allows individuals to seek damages for inaccuracies in government records, as demonstrated in a case involving wrongful identification flagged by a custom database.
Advanced surveillance technology. Advances in information technology like surveillance cameras and satellite-based tracking systems offer unprecedented data gathering capabilities but raise concerns about individual privacy. Proponents argue that privacy expectations are reduced in public spaces, exempting them from Fourth Amendment protections. However, critics worry about potential abuses, such as storing images without consent, leading them to intimidation or blackmail. Additionally, accuracy concerns highlight the potential for misidentification, amplifying privacy risks associated with these technologies. Surveillance cameras are increasingly prevalent in major cities worldwide, aiming to deter crime and terrorism. Critics argue they infringe on civil liberties and raise concerns about cost and monitoring efforts. Proponents cite anecdotal evidence of crime prevention and the camera's role in solving cases. For instance, Great Britain boasts 4.2 million CCTV cameras, while Washington, D.C. monitors over 4,500 cameras in school and public transportation hubs. The Chicago Transit Authority credits its 7,000 cameras with a 23% crime rate reduction on its system. New York City's Domain Awareness System, a partnership with Microsoft, integrates surveillance cameras, radiation detectors, and license plate readers to enhance security and response capabilities. Despite concerns, officials emphasize the system's potential benefits and downplay comparisons to Big Brother surveillance. Vehicle event data are devices installed in vehicles to record data before, during, and after a crash. Triggered by airbag deployment, they capture information like vehicle speed, seatbelt usage, airbag deployments, and driver inputs such as braking and turning. While not mandatory, some vehicle manufacturers voluntarily install EDR with capabilities varying by manufacturer. Since 2011, the National Highway Traffic Safety Administration requires a minimum set of 15 data elements to be captured by EDRs in vehicles. EDR can be used by manufacturers to improve vehicle performance, and it's admissible in court proceedings, subject to state laws regarding ownership and access to data. Court cases have been EDR data play a significant role in determining accident details and liability. Stalking apps, also known as cell phone spy software, enable the individuals to track someone's locations, record calls, monitor text and pictures, and even activate the phone's microphone remotely. Popular examples include Mobile Spy, ePhone Tracker, Flexi Spy, and Mobile Money. While there are no laws against creating such apps, installing them without the phone owner's consent is illegal, as is listening to calls without permission. Despite legal restrictions, determined stalkers will use these apps. The Senate Judiciary Committee has proposed a bill to hold software companies accountable for improper use of stalking apps, requiring disclosure and permission from phone owners before sharing location data. There's an exception for parents who wish to track their minor children without their knowledge.